Let's proceed.
Mr. Chief Justice, and may it please the Court, the issue in this case is whether assault by means of a dangerous weapon is a lesser included offense of armed robbery. The appeals court read this court decision in Wicks as changing the standard, as altering the review for lesser included offenses. I don't think that the court meant to change the longstanding rule, which in Massachusetts is explained in Muller versus Commonwealth, and that is that if one offense contains an additional element, which means that it requires the Commonwealth to prove an additional fact, and the other offense also contains an additional element, a different element that requires the Commonwealth to prove an additional fact, those offenses are not the same offense for the purposes of double jeopardy. And in this case presents an opportunity to, it's almost a textbook perfect case to demonstrate that assault by means of a dangerous weapon is a lesser included offense of armed robbery. And in fact, the indictment in this case used the same language in both indictments, both for the armed robbery and for the assault, exactly the same language, and the Commonwealth did not have to prove any additional fact to convict the defendant of assault by means of a dangerous weapon. I would like to just refresh the Court's memory about the Muller case. It's a pretty old case.
Yes, the question is, do we have to reverse Vic or overrule Vic in order for you to prevail here?
No, Your Honor, I don't believe that this Court did change the rules in the Commonwealth in Vic. I mean, the Commonwealth, this rule was always the rule in Massachusetts. It's cited in Blockberger, and I don't read Vic.
So you're saying that you meet the elements test here? I mean, isn't there an element in armed robbery that is an intent to steal versus?
Yes, there is. There's a greater offense. Armed robbery is the greater offense of the assault. Armed robbery always understood as assault and larceny. That's what is always understood.
But in armed robbery, you don't have to use the dangerous weapon, but with assault by means of a dangerous weapon, you do have to use the dangerous weapon, don't you?
Well, actually, the Commonwealth cites cases that say that all you have to do is refer to it. An assault is, there are two different branches of assault. So I think that what happens, the way the Commonwealth cites the cases, sometimes they use one branch of the assault and sometimes the other. But the Commonwealth didn't have to prove any additional facts in this case. And that's why I think that there's like a misunderstanding about what the Commonwealth has to do to show that there is an additional element.
Well, the difference is that the Commonwealth claims that armed robbery means that the person was armed but need not have committed the robbery by means of the weapon, but assault by means of a dangerous weapon is an assault by means of a dangerous weapon. It must be with the dangerous weapon. It must be used in some fashion.
You can, they actually cite cases that show that that if you threaten somebody that you have a weapon, that's enough for assault.
But that's using it. That's using it. I mean, that's a form of using it. For the armed robbery, you could just keep it hidden in your pocket.
Well, and the same thing with robbery. You can commit a robbery only by telling somebody I have a weapon. So the point here is that you have to show what additional fact the Commonwealth proved Had to prove. Had to prove.
I guess the question is, let's imagine somebody walks into a bank, hands the teller a note which says, give me your money. The person does give the money, and the person walks out, and then he's arrested, and it turns out he has a gun in his pocket. Never mentioned it, never used it. Is he guilty of armed robbery or just of robbery?
Well, I don't think that it's necessary to answer this question here. If we're going to decide that it's necessary for armed robbery, it's not necessary to actually let the person know I have a weapon. It's a question of how we're going to construe that statute. But there is a.
No, go ahead.
But there is an implication that I have a way to do something if you don't give me the money. I just want to refer the court briefly to the page 10 of the Commonwealth's brief, where they say that a person is guilty of armed robbery as long as he persuades the victim to part with his money. That has never been. And it turns out that he actually has some weapon. Now, weapon, under the decisions of this court, could be sometimes a sharp pencil could be used as a weapon.
Yeah. But if we agree with the analysis that you've just described, it seems to me that's a fact-based analysis and not an elements-based analysis, and we would have to overrule Vic.
Well, Your Honor, I disagree that it's fact-based, because it does say that and the Commonwealth doesn't show what fact, in this case, they had to prove for a conviction of assault by means of a dangerous weapon that they didn't have to prove for a conviction of armed robbery. And I have not been able to figure out what fact. Element means fact. There has to be a fact that is not required for one, and the other one has a fact that is not required for the other one. That's how we know that they are not the same offenses. But here, once they proved armed robbery, they proved assault by means of a dangerous weapon. Nothing else was required that they had to prove. So I wanted to give the example of Murray because that's a very important case cited in the Supreme Court case, Blackburger, which is a case of statutory interpretation. The court does not have authority to sentence a defendant without the authorization from the legislature, and we don't have it here. I would just want to mention that the Santos case that the Commonwealth relies on, and in fact, in Santos, the court held that it is a lesser included. Obviously, the legislature was aware of the Santos case. If they disagreed and thought that there should be a separate punishment for assault by means of a dangerous weapon and armed robbery, they should have spoken, and they have not. So I would say that you cannot, a court cannot then sentence somebody for something that's not authorized by the legislature. And in this particular case, when this alleged offense was committed, the rule was the Santos case. Now, I think that the Commonwealth misinterpreted Santos, and I believe the appeals court misinterpreted it, because in Santos there were other incidents of assault, but so the defendant could have been convicted of separate assault by means of a dangerous weapon, but the prosecutor in that case argued that particular assault that had to do just with the armed robbery. So the court said, because we don't know whether the jury found the other facts, that's why you cannot find him, that conviction cannot stand. I rest on my brief.
Thank you, Counsel.
Good morning. May it please the Court. Hallie White-Spate, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. Your Honors, this Court spoke unequivocally and unambiguously in Vic. We look only to the elements of the offense in determining whether one crime is a lesser included offense of the other. We look at the elements abstracted from the particular facts used to prove them. We do not look at the evidence in a particular case. And looked at this way, assault by means of a dangerous weapon is not a lesser included offense of armed robbery. Even the court in Santos says it's not technically a lesser included offense. Not technically really means not. Santos comes out the way it does because of an unwise concession by the Commonwealth that it was, based on the elements, a lesser included offense. And this court acknowledged that fact less than a year later in Commonwealth v. Jones, that Santos is limited to its own facts, its own circumstances, and the way it was argued. I don't see how this court can rule that assault by means of a dangerous weapon is a lesser included offense of armed robbery without essentially overruling Vic. Porro is not to the contrary. To the extent that there is a concern about the language in Porro, about exceptions that have been made to the elements-based test, I don't think that need concern this court. The issue in Porro is not offenses with separate elements. It's different ways of fulfilling a single element, the two separate forms of assault. And Porro actually cites Santos extensively to that, for that purpose, that there aren't different elements of assault. There aren't really even different theories of assault. There are simply different ways of proving assault. That is, different sets of facts that can prove a single element. There was no dispute about the way the assault was committed in this case. There was no question that it was the same action that constituted the assault element of armed robbery and the assault element of assault by means of a dangerous weapon. The question is whether that phrase, by means of, in the assault by dangerous weapon statute, means anything. And the defendant asks this court either to read it out of the assault by means of a dangerous weapon statute or to read it into the armed robbery statute. And this court should decline to do either of those things. The legislature saw fit to include that phrase in the assault by means of a dangerous weapon statute and not to include it in the armed robbery statute. The fact that they did not go back and amend the statute after Santos suggests that they understood that Santos is confined to its own facts and circumstances. The two offenses target related but distinct social harms. In the one case with armed robbery, where, as this court has correctly pointed out, a person could walk into a store, gun in his pocket, say, "Give me the money," and walk out. He never pulls the gun. He never refers to the gun. The victim is never aware that there's a gun. He's still guilty of armed robbery, but he is not guilty of assault by means of a dangerous weapon. The danger there, the risk, is the harm that can be caused by that weapon. There is an additional and distinct risk associated with assault by means of a dangerous weapon. First, there is the simple fact that we are targeting not the taking of money, not the taking of property, but putting people in fear. But also there is the risk that the threat of a weapon and the threat of the use of a weapon can spark retaliation. And I draw the court's attention to Commonwealth v. Henson, where the defendant pointed a gun loaded with blanks at a man who, it turned out, unbeknownst to the defendant, was an off-duty police officer, who then pulled his own weapon, which was loaded with real bullets, and a gun battle ensued with the victim firing real bullets at the defendant. That's a different kind of harm than the harm that we target with the armed robbery statute. My sister argues that there was no additional fact that needed to be proven to convict the defendant of assault by means of a dangerous weapon. But in fact, if the only evidence we had was he came into the store, he said, let's split the money, I gave it to him. He had and we found out later he had a gun, then he's guilty of armed robbery. We needed an additional bit of evidence. He took the gun out, he put it on the counter, he said, let's split the money. And that is what makes these two offenses different. And if the court has no questions, the Commonwealth will rely on its brief and ask you to affirm both convictions. Thank you.
Thank you.